amendment, and actually the Constitution has been always read that defendants are innocent until proven guilty. That's the United States Constitution too, of course. And judges routinely would set bonds based upon allegations containing complaints. So a couple years ago, New Mexico changed that. And now we're required to determine whether the accused, whether there's evidence that the accused are dangerous to the community. And in addition, whether there are any conditions of release that would protect the community if in fact they have been shown to be dangerous to the community or to another person. That showing is on the state, and the state has to prove that by clear and convincing evidence. And that is the second highest burden in the law. What I've heard here today is troubling, definitely. Troubling facts about numerous children in far from ideal circumstances and individuals who are living in a very unconventional way. Although if you have lived in northern New Mexico for any period of time, you are aware that many people here live in unconventional ways. So they were living in an unconventional manner. They were living with their children there. There is, the most troubling aspect of this case to me is the fact of the young child who apparently died in the compound. I don't have any evidence before me about any conditions with respect to the other children that were there. I do know now that they are all in state custody. They are all in foster homes, and they are no longer in the location where they were located. The state alleges that there was a big plan afoot that the state hasn't shown, to my satisfaction, by clear and convincing evidence, what in fact that plan was. None of these defendants have a criminal history that I have been aware of, except for Sarah Bohaj, and he is only an allegation of interference with custody of the young child. They're in their mid-30s to 40s. As a longtime trial judge, I would say that most people, if they're going to get into crime, get in there young. And by the time they're in their 30s and 40s, if they don't have a criminal history, it means they probably don't have a criminal history. So there's no reason for me to believe that these defendants have in the past shown themselves to be a danger to the community. The state wants me to make a leap, and it's a large leap, and this would be to hold people in jail without bond, based upon, again, troubling facts. But I didn't hear any co-ed plan that was being alleged by the state. I'm going to deny the petition for pretrial detention pending trial. I believe that there are reasonable conditions of release that can be fashioned to protect the community, and these are going to be the conditions. Each defendant will be required to post a $20,000 unsecured appearance bond. Until stable housing is acquired, each defendant will be fitted with a GPS ankle monitor. Each of the defendants will be cooperating. They all have children in Taos. Each are going to be required to cooperate with CYFD, that's the Children, Youth, and Families Department, who currently has custody of these children. They are to obtain housing, stable housing. They are to maintain weekly contact with their attorneys. They are to attend all future hearings in this case. There's no evidence of this, but I always impose the requirement that they not consume alcohol or illegal drugs. They're not to have any firearms in their possession, not to have any other dangerous weapons in their possession. Nobody is to leave the county without permission of the court. They are only to have supervised contact with the children that are in state's custody. At such time as if the defendants do acquire stable housing, they may request a release from the conditions imposed in terms of the GPS monitor. The state also has the option at any time to renew their motion if additional facts indicating a substantial threat to life. Is there anything further from the state? Mr. Haskins.
Yes, Your Honor, we would ask the court to order that the defendants not discuss these cases with their children if they have contact with them, or
Yes.
really with each other.
Yes, all right. I think that is appropriate. You're not to discuss any of the facts of this case with any of the children, and you're not to discuss it among yourselves. Mr. Clark.
I have a logistical question. Do you have any conditions of release? Will the court prepare those, or does that rest on us? And if so, do you have the forms handy?
We can do it.
Okay.
Yeah.
I'd be happy to. I just don't see the forms laying around.
All right. Mr. Kostic, you can do it, right?
Maybe I'll delegate that.
All right.
No, one additional matter, Your Honor, is that, you know, the matter of the GPS and maybe the house arrest condition to ensure that it is paid for.
All right. So Mr. Kostic was requesting house arrest with GPS because that would require the county to provide that GPS at the county's. Is that a request from everybody?
Yes, no objection from my client.
Yes, Judge.
All right. And in fact, so house arrest would be ordered. The exceptions would be to meet with your attorneys, attend any medical appointments and your appointments with your children, and those would be the conditions.
And Your Honor, to our knowledge, the compound in question has no running water, electricity, heat, or anything else, and is really not fit to live in. I think it goes without saying, but maybe the court should say it. It doesn't qualify as the stable housing the court's looking for.
Because at this point, there's no, as I understand, no electricity, and I'm not even sure whether they can take a signal there, so the monitors have to be in place. You can of course visit that question if you need to. So, court will be in recess. Thank you.
All right.
Yeah, all right.